My name is Mark Hocker. I am your judge of Lubbock County Court at Law No.1. I was appointed by the commissioners after Judge Rusty Ladd's untimely death, and I have been serving in that role since December the 21st of 2011 when I was sworn in. Barbara asked us to talk about what we're for and what we're against, and that'd be a neat thing to do. I think my opponent and I would both say that we're for justice, we're for law and order, we're for conservative Christian values like all of you in this room, and that's why we gather together here, because we have those similar values. I am for seeing that justice is handled fairly and impartially. I am foreseeing that justice is handled efficiently. I am foreseeing that when you're called for jury duty, your service is purposeful and meaningful, and that we don't waste your time any more than we have to. I know that's difficult sometimes, and I know nobody looks forward to getting that jury summons. You think, oh man, I'm going to go down there and get herded around like cattle and wait in little rooms for long periods of time. And to some extent that is going to continue to happen. There are certain things that we cannot avoid. We have a central jury pool process where we have everybody report to one location, and then we divide you up into the different panels for the different courts that are needed for that day. And I only have control over one court at this time, so I don't have any ideas about having control over any more courts than that. I'll only ever be able to do things one way, but I hope that I do things well enough that others will take note, and that your jury service will be more meaningful, that your time will not be wasted, and that you'll appreciate it when you do serve. I find that most people that serve really get something special out of that. It's such a uniquely American and wonderfully constitutional thing to do. In order to make sure that our cases move efficiently, which I believe in doing, I have instituted a scheduling order. And I can show you that today. This afternoon, and you probably can't see that from here, but let me tell you, we've never had a scheduling order in a criminal court in Lubbock County before. This is a new thing. And the purpose of this is the Supreme Court requires us to resolve our cases within 6 months of arraignment. And we do a pretty good job of that, but we don't get them all done that quickly. We don't do as many as we should. And we're never going to get 100% resolved that quickly, because some people run off. And some people commit felonies which have a much longer timetable, and the misdemeanor has to get resolved with a felony. See, County Court at Law No.1 is a misdemeanor court. We primarily handle just criminal misdemeanor cases, a little bit of family law, the occasional civil case, occasionally hear probate, prove up, like I did this morning. But the large bulk of what we do is criminal misdemeanor work. And by instituting a scheduling order, I'm setting out an expectation from the beginning of the case, from the date that the person is arraigned. You're going to have this much time to get a lawyer hired, and we're going to work with them. If they're on bond, which most people are, we want them to go out and spend their own money to hire a lawyer. It shouldn't be the citizen's burden to provide them an attorney. If they had money to get out of jail, they ought to have money to go hire a lawyer. And we're going to ask them to at least make an effort to try to do that. Obviously, if they qualify as an indigent and they are entitled to a court-appointed attorney, we're certainly going to give them that opportunity as well. But if they made bail and they got a job, let's see if they can try to hire one. We're going to set some deadlines for the production of evidence. In criminal cases, it's kind of one-sided. The state has to show all their cards. The defense only has to show their experts that are going to testify. But the defense cannot advise their clients properly and make a fair evaluation of their case and what it's worth without seeing how much evidence the state has against it. So we're going to have a deadline for the state to turn that over. And then we're going to have a time for the parties to report to the court on how they're doing with their negotiations and talking to each other. We're not going to make them sit in little rooms and force them to negotiate in a little room. We're going to treat them like big boys and girls, and like the rest of the bar, they can negotiate freely on their own time and come to a resolution, but the court is going to stay involved and find out where they are in the process along the way, and we call those status conferences. And then we're going to have a deadline for filing of pretrial motions, non-evidentiary type. I have 1 minute left. I'm going to get through this. And then we'll have a non-evidentiary pretrial hearing, and the motions will be filed ahead of time so those hearings move quickly. And then we'll have a deadline for the filing of evidentiary pretrial motions, such as to suppress or quash, and then we'll have the actual evidentiary pretrial hearing itself, and they will have a docket call and then a trial date. And they'll know their trial date from the day that they're arraigned. It'll be about 149 days out, or 5 months. And if we don't get it tried the first time, then that still gives us time to get that resolved within 180 days. Would you believe out of approximately 2,500 cases in my court, we have we have 54 that are currently set for pretrial. We only have 20 cases that are actually set for jury trial at this time. And every one of them has a trial date, and every one is going to get reached. And I'm taking control of that, and I'm making sure that these cases are handled timely, and handled responsibly, and people are treated fairly. because that's the most important thing about a judge, is that you treat people fairly. Thank you for your time.
Reference to clearing the docket, moving cases through the court system, and the fact that that costs, I'm sure, the county a lot of money, and probably the individuals as well. And I guess my question is kind of multifaceted, but if you guys can talk to this, I would be interested in knowing, because it seems to me that if that is a prevalent issue, and it seems like from y'all's comments you're saying that the court system currently doesn't do a very good job of that, or hasn't historically, and so if that's the case, why would that be, and is there some reason that we don't know about? And then I guess the other side of that is, to make that work, clearly the answer is leadership. And so I'd just be interested in hearing your opinion on why that is a problem in the first place, because it sounds simple, so why is it a problem? And then secondly, if you could describe maybe y'all's style of leadership and what you bring to that situation, and how your leadership style can make that happen.
Mrs. Manager, what is your name, sir?
Jerry Shelton.
Jerry, very nice to have your question, and thank you for asking that. And I want to answer that in several different ways, because I think there's multiple parts to it. At least that's how I understood it. Our trial docket system clogs up in a couple of different places. And it can bog down at the jury trials, but that's usually not the real problem. I think, as I mentioned before, we move approximately 2,500 cases through each county court at law, of our two county courts at law that handle criminal cases, each year. The district attorney files about that many cases, and we resolve about that many cases a year. That didn't used to be the case. 10 years ago, when Judge Ladd and Judge Farmer came on the benches, there was a significant backlog, and they worked, and the DA worked very hard to reduce that backlog. And so we now have kind of an equilibrium, but we're not achieving the goals that the Supreme Court mandates, and that our local county rules mandate, that we get these cases resolved in a timely manner. But when you realize that there's only 20 cases, 17 defendants, some of them have multiple cases, that are set for jury trial right now, you realize that's not where the big clog is happening. And we actually do set cases oldest to newest, and they don't all reach the trial docket at the same time, and let me tell you one reason why. When I got on the bench, the first month or 6 weeks of settings were already created. They were already in place from the previous administration. And I went to the court coordinator and I said, when we had our first trial week, the week before, I said, what are the announcements for trial? She said, what's an announcement? I said, well, that's where the lawyers come and we have a docket and they tell us if they're ready or not, and we usually give them a number, and then that sets the order that we're going to try the cases. And generally it's oldest and newest. But there are sometimes exceptions when you have a witness, say you have an expert coming from out of town from Dallas who has a schedule, maybe he's a medical examiner, a doctor, or something else. Sometimes you have to make accommodations for special settings for certain reasons. Other than that, you generally try the oldest case first. She says, well, we don't do that. I said, how do you know what's going to trial on Monday? She says, oh, well, the DA usually sends an email on Friday and tells us what they're going to try. I said, wait a minute, where's the court's involvement in this process? How do the sites know what's going on? And so that was one of the very first things I changed. Even though that docket was set, I went in with the docket as we had it, and I said, let's have announcements. And for the attorneys that weren't there, I called them. I said, are you ready to go to trial or not? And then we sent out communications to everybody that was on that docket. We said, here's the order that we're going to try these cases in. The judge taking control of that makes that happen. But getting the cases to the jury trial point, that's where the 2,483 cases or defendants cases get resolved in the process. We resolve 99.5% of cases by plea bargain. And it is making those happen, and it is setting a deadline. That's why I was talking about the scheduling order earlier. There's a deadline from day one. Right under the old system, there was just a setting. And until that A setting became a trial setting, nothing really mattered. It is the trial that holds the lawyer's feet to the fire. But by setting a scheduling order and saying, you can do this and you can do this, but whatever you get done, you're going to trial on that date, and there's going to be a deadline. That is the judge controlling the docket, is the judge setting the schedule, giving the parties time to work out their stuff in between. Do I have just a minute to talk about leadership? Another minute.
How could I
15
not?
I do agree with Scott.
Another minute.
Thank you. I do agree with my opponent about servant leaderhood. That is certainly a concept that I believe in my faith, and I believe in as public servants. Servant leaderhood is very important. But as you may have gathered from what I talked about before, the judge must take the role in controlling the docket and making sure that the case is moved. You must treat all sides with respect and with impartiality and fairness, but there has to be a firm hand at the wheel, making sure that these things get resolved and that there is a timetable. If that doesn't happen, then cases will just linger and they'll go from setting to setting to setting to setting without ever getting resolved. It is the judge that ultimately says there is an end point, we're going to have a trial, get it done, or the jury will decide for you. And that's what the judge does. Thank you for your time this evening. What I want to leave you with is this. I've served my country in the U.S. Army Reserve for 7 years. I've worked for a living before I ever went to college. I've worked as a prosecutor and a defense attorney, an ad litem for children, and a civil litigator right here in Lubbock County. I bring that breadth of experience, which allows me to see both sides of each case and make sure everybody gets that fair shake they deserve. I'm competent and I work hard, and I will close with saying what I should have started with. Thank you to my wife, Heather Hocker, almost 16 years, and to my daughter, who is with a friend tonight. And thank you to you, and God bless Lubbock County, God bless the state of Texas, and the United States of America.